I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this lesson on New England state courts. This lesson is the second in our series on state courts, so if you haven't already, please view the introductory class for your respective state before moving on to this lesson. All classes can be found in our FOI guide at NEFAC.org, as well as on our YouTube channel, 5 Freedoms. In addition to state courts, we also offer lessons on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. SBJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you for joining us for this webinar, which is brought to you by the New England First Amendment Coalition. Now, this session is going to focus more deeply on the courts in Rhode Island. And with us is attorney Ray Marcaccio, and he's going to explain in greater detail how the courts work in the Ocean State. Ray, thank you so much.
Oh, my pleasure. Hi, everybody. Yeah, I'd like to just spend a few minutes going through just the legal underpinnings of how you or the rights you have to gain access to our judicial proceedings, as well as our judicial records. And there are a number of rights that come into play, but I thought we'd spend just a few minutes on that, talk about how that practically applies to you as a member either of the media or the public, because really the rights that the media have, that the press have, are the same as and come from the rights of the public. There are no distinct rights that arise from anyone who is practicing as a journalist. So when the press or the remaining members of the public want to gain access, we'll just talk about how that would look like. Is the door really open? Can you really get into all proceedings? What proceedings can't you get into? And then if things go wrong, I'll just try to give you some direction as to what you might be able to do, even if you don't have a lawyer, you're out there, you want to get access to something you think you have a right to. So this will help you know whether indeed you do have a right, and if so, what you might be able to do to perfect that right and gain access. So let's just start here. I want to just note that your rights really emanate from 3 different ways. The first is the constitutional rights that sometimes come into play, as well as the court's common law rights that basically are judicial decisions, separate and apart from any cognizable First Amendment right. But judges have made a number of rulings, finding that in many cases, you as a member of the public, as a member of the press as well, have a common law right to gain access to certain proceedings. And then courts have in Rhode Island, we have codified through the rules of procedure, certain ways that you should be able to gain access. And if you don't, what your recourse might be. If you saw the last webinar that I gave, which just gave you basically a sense of where the courts are in the state, what they are and what they do, you might remember that we kind of left off with a rule of thumb, which is that there is a distinction between criminal and civil proceedings. And there's a hierarchy of rights. And as you go into a criminal proceeding, your rights are at their peak. The courts realize and have recognized under our First Amendment and by common law that the public right to gain access to judicial proceedings and judicial records is at its height when the government is taking away the rights of people, whether it's their liberty, or their lives. There are a number of cases on point. One of the seminal ones came out of our United States Supreme Court many years ago, back in 1980, where the court recognized that the press and the public have a First Amendment right of access to criminal trials. And again, that is the height of the rights that we have. In our own state, our courts have looked at the rights in connection with court proceedings and court records in the context of a criminal case. And the case that I had back in 1998 is still one that gives courts a lot of direction, Providence Journal versus Rogers. And that one, I think, is a good example of how this could play out if you wanted to gain access even to the judicial records relating to a criminal proceeding. That case involved a reporter who went to the clerk's office and tried to get access to numerous criminal files, dockets, criminal files that dealt with sexual misconduct by adults against children. And he wanted to find out basically how many times the Attorney General is successful. Once they bring a claim against an accused, how often does it get settled? How often do they plead out? How often is there a trial? So he was expecting to see all of this information. When he got there, he received nothing but dummy files. So the presiding judge of that court had determined that in order to protect the legitimate rights of a child from having their name disclosed, he would shut down all of the criminal records relating to each of these cases. And there were many, many that went back years, if not decades. So we sued, and our position was basically that we have a right to know what the government is doing against accused people, even in this context. And ultimately, the court agreed, saying that you can only stop a proceeding, keep the public out, or deny access to a record if the interests of the public and the courts is narrowly tailored to serve a compelling government interest. And when you see those words, compelling government interest, whether you're a lawyer or not, they should make you realize that you've got to have a really good reason to justify doing what you're doing. It has to be compelling. In the Rogers matter, the Rhode Island Supreme Court decided that the best way to protect both your right of access and the privacy rights of a minor is to create a dual docket system. So anything that could identify the minor was redacted, placed into the regular docket, or created a new docket so that, in this case, the journalist could gain access to it. Well, that's kind of a good example of how the court, especially in the criminal matter, will really make efforts to ensure that the public does have rights to as much information as possible in the criminal setting. In the civil setting, it's less. While you wouldn't say that there is normally a First Amendment right to see what's going on in a contract case or a civil case, there are still rights that you are afforded as members of the public. And they're codified in the Superior Court Rules of Civil Procedure. And they make clear that, as I'm quoting, all trials upon the merits shall be conducted in open court, and so far as practicable in a regular court. So note a few things there. They're talking about trials on the merits. And again, in the civil setting, unlike the criminal, where you don't have the same level of right to be there, the courts are going to be mindful of what level of proceeding is at. If it's a trial, again, your rights are at their height. If it's a discovery dispute, while the court is still going to be open, there may be records that are being brought back and forth that may be referenced during a hearing but are not part of the docket, and the court may not compel that they be disclosed. And as it also says here, when you do have witnesses, unless there is a compelling reason, that testimony must be taken in open court. The court records, just like the court proceedings, even in a civil matter, are considered public documents and can be provided to the public. Our Supreme Court hasn't really defined what that means, though, as far as what a court record is, and you would really have to pay attention to what level, what stage you're at in the proceedings. So as a rule of thumb, if there is a record that is introduced to a judge for that judge to decide a matter, that's going to be, in almost all occasions, a public record. So an example of that might be if you did a deposition in a case, and always when you do a deposition, there's a transcription. That transcript isn't a public record because it's not part of a judicial proceeding yet. Once portions or the whole thing are introduced as part of either a trial, a summary judgment, or any other proceeding in court, then it does ripen into a court record and should be available to you to see and read and possibly even make a copy. Our First Circuit, I remember in one case, there was a reporter who was trying to get some documents and information, but didn't go to court. And the reporter was looking for copies of information, including summaries or documents that were introduced. And the court said that since it was an open proceeding, the reporter could have gone themselves to that proceeding and seen it. There was no need for the clerk to make any special efforts to obtain information, especially for the reporter. So again, the height of this is being able to go to court, and then any documents that are there, being able to see them discussed in court. Another example to give you a sense is if you had a discovery dispute. So you're trying to force someone to give more answers to written questions that you've produced. And you've done a memo, and that memo goes to a judge. That memo may or may not be available for you to see, especially if the lawyers just sent it in to the judge to explain why something should be available through discovery. Very different if exhibits are introduced for a summary judgment and the judge has those in front of him or her and he's trying to decide that summary judgment, which could dispose of the entire case. All of those exhibits are now public documents. In addition to your right to get in the door, to see a trial on the merits, you also have rights to get in the door when there are pretrial proceedings. You may have seen the Murdaugh trial that was from, I think, South Carolina. And that was that went on for weeks, if not months. And there were fixed cameras there at all aspects of that trial. Well, the public also could have had the right, in almost all cases, to see the voir dire of the jurors. That means when the lawyers or the judge ask specific questions of potential jurors, a pool of jurors, and then decide to seat 12 or more of those people in a criminal matter. Almost always, the public has a right to even be part of that, even though it's not the trial. It's the initiation of the trial, but it's not the actual trial. So what's the practical effect of this? What are your rights? You get in the door, you're able to see this. You should be able to take notes. Can you record it? Can you photograph it? Can you videotape it? Again, whether you're a member of the press or the public, you have a right to take out your phone and start recording. That is something that the court system in this state, Rhode Island, has made a distinction between those who are taking written notes, who are either reporting it by way of writing or your own notes that you're taking to observe the proceedings versus the electronic recording, photographing, videotaping, or even broadcasting of the proceeding under that second larger electronic category. The Rhode Island Supreme Court has created very specific rules that address whether the camera, a still camera, can be used, whether you can set up a tripod with a full camera to record it, and if you can, are you allowed to move? Must you stay in one place? That's all laid out in Article 7 of the Supreme Court rules, and it goes on for several pages, and that would be probably a seminar in and of itself. There are detailed rules that deal with how the media, of course, the court is thinking of the press, but again, it applies to anyone, any member of the public. So the Supreme Court has said that the presiding judge of that case has, quote, sole discretion of whether or not you can record, photograph, or anything else electronic. And unlike some other aspects of your rights, there is no review. So when that judge says no cameras, you really have no recourse. You can take out a pen and pad and start writing, but you have no recourse beyond that judicial officer themselves. You could see, if I were in that position, I would probably reach out to the clerk. That's your contact person. But every judge has an assigned clerk. That clerk is going to be sitting in that courtroom anytime the court is in session. And that's going to be the best way to reach out and get permission first to make sure you're complying with anything that judge wants to be done, to make sure there's no interference with the proceedings. Because I don't know what's in every judge's mind, but I imagine that many of them think of it as like a surgery in an operating room. You're coming in, I'm making a decision, I'm doing something here, and I have to get it right. I don't have a second chance. Somebody's life might depend on my decision. I can't allow this to be disruptive or in some way distracting to either the jury or to me as I'm trying to make decisions and conduct the proceeding. So Article 7 is key, and you can gain access to that just by putting in Rhode Island Rules of Civil Procedure. If you Google that, you'll immediately come to our rules of procedure. There are both Superior Court rules, but in this case, it's the Supreme Court rule, which means it applies to everybody, every court in the state, no exceptions. So that's an important one just to look over if you were thinking of going in and doing something in electronic mode. Again, that rule only applies to those who are doing it that way, not to the written recording. You likewise have rights to post-trial proceedings. Those will be taking place either with the judge who's hearing something like a motion after the judgment's been entered, or our Supreme Court. And the Supreme Court, when it meets, that is an open session. You have the right to be there so long as there's a seat available. Now, if you wanted to gain access to court records, one way that you can do so now is there's a portal, and I think I have a site to that in a minute, but if you're in the courtroom, if let's say you're in the main courthouse in Providence, which is for the state Supreme Court, as well as the Superior Court, you can go to the Superior Court clerk's office on the 5th floor. And I believe, if I'm remembering correctly, I think there are 2 computer terminals towards your left. You go there and you have a right to put in the name of any party. And what should happen, and it does, is the whole docket should pop up. You can then ask to see that docket. Or you could gain access at least to that docket entries through the computer right in the courthouse. And I believe that every single one of the superior courts, every county, all 5 of them, have a similar access. But the one I'm thinking of is our main courthouse here in Providence. The other way to get access is through the website courts.ri.gov. That will give you access to all of the court dockets going back a number of years. I'm not sure, but I think it's at least, at this point, at least 10, if not 15 years of electronic dockets that will be available for you to see what's taking place in any particular case. The Supreme Court, which is also under that website, has its own designation, and you can see the calendar. You can see exactly every time the court's going to be meeting for the rest of the year. You can read the dockets as to every court that's up on appeal. They also publish their own decisions, so you can gain access to it that way, to that information as well. So you're there, you're not causing any trouble by snapping too many pictures, you're not disrupting, but you want to just be present. And you want to be present in a criminal proceeding, but for some reason it's denied. One, you should be there in the proceeding, at least at the initial part, where the court will likely tell you why they are closing the door and you can't get in. They should be specifying on the record the reasons why they're doing so. And I think I have to just jump ahead here a little bit. If this was a criminal proceeding, you do not have a right to intervene in that exact case, even pro se. What you need to do is file a separate action in the Superior Court called a declaratory judgment. You go in and you say, I, as a member of the press, I, as a member of the public in general, seek a declaration from another judge to say that I have a right to be in that proceeding taking place in Judge Number One's chambers, courtroom, which was just closed. And that would then give you the opportunity to have a hearing by another judge, basically suing that first judge, seeking a declaration that you have a right to be in that proceeding. Now, the reason why you do it that way is because the Supreme Court does not want you to interfere with the judge who's closed the courtroom. That judge is involved in a criminal case, and again, that's the pinnacle, right? That's when the government is taking away something from a person, some liberty interest. So the Supreme Court doesn't want you trying to intervene in that very case because it might be disruptive. That's not the case if this was a civil case. Again, if you're trying to gain access to the room and the judge takes the bench, he or she will announce, I'm about to close my courtroom, and here are the reasons why. Here's the privacy interest that I need to factor in, and my sheriff is going to instruct everyone to leave. Listen to it carefully, assess it, because even the Supreme Court is going to just use a reasonable application of these rules. If it makes sense to you, then you probably will assess whether you'd have a chance of winning. But if you think that it's inappropriate for you to be excluded, and you probably will be thinking that because all proceedings should be open, then you have the right to file a claim in that case seeking what's called a motion to intervene in that very lawsuit, trying to gain access to it. And that would be heard by the very judge who made that decision and then could be appealed. Now, admittedly, that's not the least costly way, getting a lawyer. It's time consuming, but there are resources available to you if you're pro se, you don't have access to a lawyer. There are things you can do, and one of which I think is not often thought about, but our Supreme Court Law Library, the librarian, the chief librarian there, Colleen Hanna, it's just a tremendous resource. Between her and all of the staff there, If you went in, they would all, in all likelihood, try to get you some information that could help you. There are many, many cases on point. We have the media law reporters, where they have a whole section of cases just on gaining access. And the staff are very, very helpful there. And I'm sure they would show you what sections of the library have that information, and you could read it. There's also electronic access. That's located at the very top floor, the second to top floor at 250 Benefit Street. So it's right above the Supreme Court courtrooms. And that's on the 7th floor. So that's something that you should consider. The Superior Court, again, for every one of the counties, there is a main Superior Court clerk's office. They likewise may be able to, one, direct you to the clerk who has that judge. So you can talk to that clerk, find out if you can have some kind of a filing for the judge to understand why you want to get it reopened, and could have access to other information as well. But the Supreme Court Law Library, you likely would get even the forms you would need. There are no blank forms I can think of, but the basic information you want to put into a declaratory judgment to get this heard. Obviously, NEFAC has great resources. They may be able to at least give you some guidance by, if you contact them. Another resource here in our own state is the ACLU of Rhode Island. Steve Brown is the executive director, and he is omnipresent here in the state with a number of access issues, and they may be able to give you some information as well, or some guidance.
Tim White asks, if a judge denies access to electronic media, can we seek a written reasoning on the docket in the moment?
That's a tough one, Tim. I think the court, are we talking about a criminal or a civil proceeding? I mean, if it's a criminal one, it gets into that whole thing of disruption. So you would not be able to obtain that, couldn't get that for sure. You could, yeah, okay, criminal for sake of example. I think most judges would be willing to accommodate that request, especially if there is a significant interest in the public, and presumably there is. But there's no requirement. The suit would have to be by another judge. There would be no requirement for the judge you're talking about, stopping any part of the proceeding to answer that question. That being said, if the judge doesn't put something on the record without even being asked as to why that's taking place, disruption or whatever else, then they do run some risk. But forgive me, because now that we're talking about electronic media, of course, as opposed to written, there is no recourse. It's that sole discretion for that presiding officer. So if they decide not to even put something on the record, it's risky for them, but no one's ever going to review it. So you can't really compel it. We did have several years ago, we had one matter where the Superior Court judge, who's now retired, allowed a team in to record the criminal proceedings. This was a trial. And the camera was placed exactly where the judge allowed it to be placed. Unfortunately, when the recording took place and was broadcast on a local station, it showed the handwritten notes of the trial attorney up on the podium. So the lawyers facing the witness and the judge, and the camera person is just unwittingly showing that whole thing, but unfortunately it showed the handwritten notes. And we were all called in the next morning for quite a shellacking by the judge for doing that. She did allow the camera to stay, but that is, you know, a case where something's going wrong with electronic media. They have sole discretion, but even in that case, in my sense is that the judge really was trying to do the right thing, despite being pretty angry that it occurred that way. It wasn't intentional, and the judge allowed further broadcasting after an appropriate apology.
Ray, thank you so much for teaching this great webinar. I encourage everybody to check out our previous episodes on NEFAC's YouTube channel and our website, nefac.org. So thanks, everybody. Until next time.
Okay, take care, everybody.